matter of U3 against Secretary of State for the Home Department.
This appeal is concerned with the approach that the Special Immigration Appeals Commission, SIAK for short, should take to the assessment of national security in appeals brought by people who have been deprived of British citizenship or refuse leave to enter the UK on grounds of national security. The appellant was formerly a British citizen. She has 3 children who are British citizens and live in the UK with members of her family. She lived in ISIL-controlled territory in Syria between 2014 and 2017. In 2017, the Home Secretary made an order depriving the appellant of her citizenship on the ground that she was satisfied that deprivation was conducive to the public good, as it was assessed that the appellant had travelled to Syria and was aligned with ISIL, and that her return to the UK would present a risk to the national security of the UK. The appellant was also refused leave to enter the UK. She appealed against both decisions to SIAK. SIAK dismissed the appeals, and the Court of Appeal dismissed the appellant's further appeal. She now appeals to the Supreme Court. Her appeal is brought on the basis that SIAK adopted the wrong approach. It's argued that SIAK should decide the facts which are relevant to the national security assessment for itself on the balance of probabilities. If it concludes that the decision under appeal was taken on the basis of a factual assessment which was materially incorrect, then it should allow the appeal and send the case back to the Home Secretary for reconsideration on the basis of SIAK's assessment of the evidence. In particular, it's argued that SIAK should have decided for itself whether the appellant was aligned with ISIL. Submissions were also made on behalf of Justice, which argued that if SIAK made findings of fact in relation to matters which had not been considered by the Home Secretary at the time when her decision was made, then the appeal should be allowed, unless the decision would inevitably have been the same, even if those matters had been taken into account. The Supreme Court unanimously dismisses the appeal. It holds that SIAK approached the issues in the present case on essentially the proper basis, and that certain errors which the Court identifies in the approach adopted by SIAK, and more particularly by the Court of Appeal, had no effect on the outcome of the appeal. The Court begins by explaining that an appeal to SIAK is a genuine appeal and is different from an application for judicial review. In the first place, appeals can raise questions of fact as well as points of law. Secondly, unlike in most judicial review proceedings, SIAK is not confined to considering material which was or ought to have been available to the Secretary of State at the time when her decision was taken. It can consider other material, including evidence which has only subsequently come into existence. Thirdly, when an appeal is before SIAK, the Home Secretary's national security assessment is updated to take account of the evidence admitted during the appeal proceedings. SIAK then treats the Home Secretary's updated national security assessment as superseding the original one. It's undoubtedly within SIAK's jurisdiction to make findings of fact when they are relevant to the issue it has to decide. It does so on the balance of probabilities in accordance with the general rule which applies in civil proceedings. However, not every issue which SIAK may have to decide in an appeal can be determined by making findings of fact on a balance of probabilities. In particular, where an appeal challenges the Home Secretary's assessment that the appellant poses an unacceptable risk to national security, the nature of that issue requires SIAK to adopt a different approach. That is because the question whether a decision is justified on the ground of a risk to national security is based on a judgment that an unacceptable risk exists, not on the existence of a particular fact or the occurrence of a particular event. The existence of a risk can be established by evidence which is sufficient to establish a possibility but falls short of proof on a balance of probabilities. The evaluation of a risk then depends on such factors as the degree of risk, the possible methods of addressing the risk, and the gravity of the consequences if a risk eventuates. In practice, the assessment of risk in the context of national security will often be based on a number of items of information or intelligence, individually inconclusive, but cumulatively giving rise to reasonable grounds for an apprehension that, for example, the person in question has been in contact with terrorists and has aligned with their objectives. Those possibilities do not have to be proved to have occurred on a balance of probabilities in order for it to be reasonable to conclude that the person would present a risk to public safety if he or she returned to the UK, or that the risk is sufficiently serious to justify a deprivation decision. Subject to one qualification, the Court considers that SIAK adopted the correct approach in the present case. The qualification is that SIAK approached the appeal against the deprivation decision on the basis that it had to decide whether the Home Secretary could rationally assess, as at the date of her decision, that the appellant posed a risk to the national security of the UK. However, as I've explained, it's possible for the appeal to be based on evidence which was not before the Home Secretary at the time when her decision was taken, and for the Home Secretary's assessment to be updated during the proceedings in the light of that evidence. Nevertheless, in the circumstances of the present case, that misunderstanding had no effect on the outcome of the appeal to SIAK. In relation to the appeal against the refusal of entry clearance, the Court rejects an argument that SIAK's procedures did not meet the standards required by the European Convention on Human Rights. Appeals of this kind are adversarial proceedings before an independent body competent to review the reasons for the decision and the relevant evidence. The appellant can challenge in an effective manner the allegation that he or she represents a danger to national security, and SIAK can allow the appeal in cases where the assessment has no reasonable basis in the facts or is otherwise unlawful or arbitrary. In the present case, SIAK also carefully assessed the best interests of the appellant's children and properly concluded that the interference with their convention rights, which would result from the refusal of the appellant's application for entry clearance, was proportionate. The appeal to the Supreme Court is therefore dismissed. The Court will now adjourn.